Good morning and welcome to Flash Briefings by Manning Fulton. Today's topic, the new workplace, is the first of Manning Fulton's Flash Briefings designed to provide you with key legal insights in support of your business objectives, and to do so in a manner you can quickly digest. My name is Alan Dickinson. I'm the Director of Client Relations here at the firm, and I'm very glad you could join us. It's my pleasure to introduce my colleagues, Will Cherry and Jessica Vickers, two exceptional litigators who will be leading today's session. One quick housekeeping note, you will have the opportunity to submit questions this morning by typing those questions into the questions pane of the webinar's control panel, and we encourage you to do so at any time during the presentation. If we are unable to address your questions during the session itself, either Mr. Cherry or Ms. Vickers will contact you directly following the presentation. And with that, I turn it over to Will.
Good morning, everybody. Thanks for joining us this morning for this topic. Just want to reiterate what Alan said about questions. I like whenever I do presentations in person or online like this, I want to talk about what you guys want to talk about. So if you have questions, if we say something that sparks a question, feel free to type it in. We can see them as they're posted, so we'll try to answer all the ones that pop up today. What we want to do, we've tried to select a handful of topics that we've been getting questions from our clients on over the last month to 2 months. So this COVID has gone in a couple of waves. Initially, everybody's scrambling, not sure what's going on. OSHA comes out with guidance, EEOC comes out with guidance, the CDC comes out with guidance. Probably most of you on this call are fairly familiar with the basics of that. And so what we've tried to do today in this 30 minutes is pinpoint some things, both with respect to OSHA and the ADA, that we're getting a lot of questions about, and then have something that's a little more forward-looking as well, little more outside the box. And Jessica's going to speak at issues that you may face as a business going forward outside of the context of, what's the safety of your workplace look like, or what type of accommodations do you need to provide to employees. So with that, I'll dive straight into the OSHA issues. Don't know how many of you on this call have had contact from OSHA. I will say this, on May 19th, OSHA issued new enforcement memorandum. Now that enforcement memorandum goes to their investigators, but it is online, you can read it. And as I've reviewed that, the things that stick out in my mind are two quotes that I believe are on the first or second page of the memorandum. And it says, quote, "Eliminating hazards from COVID-19 remains a top priority for OSHA." And the second quote is, "OSHA will continue to prioritize COVID-19 cases." Nothing I've seen or read seems to have changed that anyway. I think it's probably not a surprise to anyone that these still are top priorities for OSHA. And so I want to talk a little bit about how do you prepare for OSHA to come in, anticipating that you may get a complaint or an employee may complain and they may come in. And then if they do come in, what should you do? So a couple of things. The investigators in this same enforcement memorandum are instructed to review documentation early in the process. So historically, if any of you had been involved in OSHA, what could happen is you get a complaint and then OSHA schedules a site visit. I think it's probably unlikely that you're going to get a site visit unless you're in one of the higher risk category for COVID-19 cases, healthcare, maybe in a manufacturing facility where there's a lot of people close together. You might get a site visit initially, but OSHA's worried about their investigators the same as they're worried about employees. So they're basically saying, hey, ask the employees what they're doing. I mean, ask the employers what they're doing, and ask them to provide documentation. So a few key components that I think need to be provided when you're asked for that documentation. Number one, make sure you provide a written pandemic response plan. If you're sitting on the call and you say, well, I don't have a written pandemic response plan, there's no magic to that. It doesn't have to be a 20-page document. I think what it means is you need to sit down and think about, okay, if something happens in my workplace, what steps are we going to take? What are we going to do as far as contact tracing? What are we going to do as far as closing for a day or two so we can make sure we clean possibly infected areas? And what are we going to do as we open back up and let people back in? So take a moment, if you haven't already done so, and sit down and think about what a written pandemic response plan would look like, and put something on paper. So if a complaint does come in, you can provide that to OSHA. As part of that preparation for the written response plan, I would encourage you to think through the hazards in your workplace. So in a workplace like where Jessica and I are, where we're in our separate offices and there's a few people scattered about the hallways, the hazard assessments are different there. Probably not much of a hazard here in each individual office, maybe in the conference rooms, maybe in the restrooms. Put that in writing so that you document when OSHA has come. You can document, okay, management has thought through these. We've assessed where the hazards might lie, and we've put a plan in place to address those. Also, OSHA is going to want to know about your training programs. I don't think that means that you have to sit everyone down in your organization and have a formal training program like you would for some type of safety orientation at the commencement of employment. But I do think what that means is that you need to have provided email correspondence or memos or online recordings to your employees so that they are trained, they're aware of what the company's protocols are. I think based on my review of the enforcement memorandum, if you're missing any one of those three things, I think that may increase the likelihood that OSHA raises an eyebrow, looks at your business a little more closely. I view those as kind of the base threshold issues. The other issue I think they're going to want to see especially here in North Carolina, where there is a mask requirement, they're going to want to see that you have some type of mask or face covering requirement. There is nothing in the OSHA regulations that govern COVID-19. There's nothing in the OSHA regulations that govern pandemics. But what OSHA has said is that there is a PPE requirement in the regulations, and normally that wouldn't apply to a business like we're in here in a law firm or maybe some other office related businesses, but it's going to apply now. And what that means is you need to have some type of face covering policy in place to protect your employees. Now, what that policy looks like, where employees are required to wear them and not, depends on your hazard risk assessment, in my view. Also, keep in mind that I stated that OSHA doesn't have pandemic regulations. The other regulation they're citing as authority to address these COVID-19 issues is just their general requirements regulation. And what that says is an employer has a duty to provide a safe workplace to their employees. So if you think about that, I think it's reasonable for them to say that they have the authority to govern or to investigate COVID-related matters on that. So think to yourself, am I taking the reasonable steps that a business in my position should take to protect my employees? One key issue, I get this question a lot, what about a liability waiver? Jessica is going to talk about a different component of that later in the presentation, but OSHA has specifically said, and I quote, "Nothing in a liability waiver prevents or precludes an employee's right to file an OSHA complaint." So in other words, while liability waivers may protect you from a negligence lawsuit, liability waivers are not going to protect you if OSHA comes and knocks on the door. Also remember that documentation is key. We've talked about this. We've talked about putting plans in place. We've talked about memos for training. Save that documentation and so that it's in one place so you can provide it to OSHA. Don't hold back. If they come asking for documentation, give them everything. In my experience, if you respond and cooperate on the front end, you're less likely to get that investigation or any on-site visit. It's not a guarantee. It's never a guarantee. But to me, if OSHA is investigating, you want to cooperate on the front end. If you get a citation, that's the time, admittedly, that you should go on more of the defensive, and perhaps working with legal counsel, particularly at that point, if not before. But work with OSHA early on in the process. Seeing no questions on the OSHA-related issues, I'll dive right into the ADA matters. We get a lot of questions, from our clients of, all right, how does COVID-19 interact with the ADA? COVID-19 itself is not a disability. That's probably the case because it's not long-term enough to classify under the ADA definitions, but undoubtedly there is a connection and there is an interplay between the two, and I want to talk about that a little bit today. It's really in three areas. Number one, disability-related inquiries. As you may know, the ADA regulates what disability-related inquiries employers can ask of employees, both employees with disabilities and employees without disabilities. It also impacts the direct threat analysis. As you know, the ADA prohibits employers from excluding individuals from the workplace unless they pose a direct threat to themselves or others. And then finally, there is some connection with the reasonable accommodation analysis. First of all, with the direct threat, the good news is that the EEU's OC has said COVID-19 poses a direct threat. What that very simplistically means is that if someone has COVID-19 or suspected of having COVID-19 or may have been in contact with someone that has COVID-19, you can instruct them not to come to the workplace, and that does not violate the ADA in any way. The real key issue, the questions we get a lot relate to the medical inquiries. Now, a lot of these are basic. Early on in the process, there were questions about, well, can we take temperatures or can we ask about symptoms? Those answers clearly now are yes, you can. While those are medical inquiries under the ADA, the EEOC has said they're very much permitted. One question I get a lot is doctor's note. If someone has had COVID or if someone is out quarantining because they traveled or because they may have come in contact with someone, can I require a doctor's note before they come back in? The answer is yes. If you read guidance on that, it says, but it may be difficult to do that. Doctors' offices are crowded. That's probably not as much the situation as it was a couple of months ago, but still, I would consider that as you're requiring notes. Do you really want to hold an employee's feet to the fire, or is it more important to get them back to work? Can an employer administer a test, a COVID-19 test? The answer to that is actually yes. I haven't actually had a client ask me that. I don't know if clients actually have the resources to do that, but if you do, you are permitted to give a test. Now, I would treat that the same as if you were doing a drug test in the office. Follow the same procedures, make sure samples are clean, make sure they're segregated, so on and so forth. What about an antibiotics test? Can an employer require someone before they return to work, maybe after quarantine or maybe after a shutdown and you're getting everybody back into work? Can an employer require an antibodies test? The answer to that question is no. The CDC has said that they are less reliable, and so the EEOC, following that guidance, has said that would be a prohibited medical inquiry. Can an employer require a vaccine? Obviously, there's no vaccine yet for COVID-19. Forward looking and trying to read some tea leaves, back in 2009, when the EEOC put out guidance on the H1N1 flu, the answer to that question was no. An employer could not require a vaccine because there are people that may have disability issues with respect to receiving vaccinations. I suspect that would probably be the same for COVID when a vaccine comes out, although COVID does present, I think, if you look at health guidance, more risk than what the H1N1 flu did. So maybe that risk balances it out and the EEOC comes out in a different direction on that. So stay tuned on that issue. A couple other issues before we shift gears here. Applicants, can you screen applicants? Can you require them to take temperatures? Yes, of course you can do that. More importantly, I think some questions that have popped up is, what if I have an applicant that either has tested positive for COVID or has someone in their family that has, or has traveled out of the state to a hot spot? Can I tell them, can I delay their start of their employment? The answer to that question is yes, you can. And in fact, you can also, if there is a situation where there's an immediate need for an employment to start and someone needs to quarantine for 2 weeks or so, you can actually, according to the EEOC, tell that employee that they no longer have a job, that you can deny employment to that person. Now, I haven't seen that play out. I question, I mean, an immediate need would really be a very, very immediate need. I'm sure there are circumstances that exist that would fall in that category, but haven't seen that play out specifically yet. And then finally, on the reasonable accommodations piece, someone with COVID is not required to receive reasonable accommodations because COVID is not a disability under the ADA. However, recall that sometimes people with disabilities may be at a higher risk for COVID. If that's the case, then the reasonable accommodation analysis may be necessary. And in those cases, that's when you would go through the same analysis. You would have the accommodation discussion and do the undue hardship risk assessment. Again, seeing no questions on that, I'll go ahead, we'll shift gears a little bit, and I'll turn it over to Jessica for a couple of new topics.
Thanks, Will. Good morning, everyone. As Will mentioned, when we sat down to brainstorm what we would talk about in this short time this morning, we tried to identify topics that we thought would be of particular interest to you all, either because they may be issues you've already come across, or looking forward, they may be things that you encounter in the coming months as we continue to live through this pandemic. So the two things that I'm going to touch briefly on this morning are recent legislation enacted in North Carolina, specifically House Bill 118, which was signed into law by Governor Cooper on July 2nd, shortly after the business sector began reopening, both for employees and the public at large on a larger scale. What this legislation does is provide a grant of limited civil immunity to businesses and individuals against legal liability for claims that someone may make that they contracted COVID at that place of business. So I'm going to run through that briefly, just some key takeaways from that legislation that might be helpful for you all to know, and then also touch briefly on employee non-compete. As we know, a good size of the working sector is subject to employee non-competes. I suspect many of you have at least some employees in your businesses that are subject to those. And given the environment of furloughs and terminations, enforcement of non-competes may be an issue that arises in the coming months. So circling back to the civil immunity legislation, as I mentioned, this legislation was enacted almost in tandem with when the larger economy in North Carolina was reopening, and anticipating that one of the concerns for businesses upon reopening is that there could be some possible legal exposure from individuals that may contract COVID and thereafter claim that they contracted it at that place of business. This legislation was enacted to try to provide some immunity and protection from businesses that were operating safely, trying to follow guidance and directives about safe operation as best they can. The state wanted to provide some protection for those businesses. So first key takeaway is that this is actually a fairly broad statute in terms of its application and who it applies to. It does apply both to businesses and individuals, and that includes nonprofits. It also includes all businesses, not just essential businesses, which we heard so much buzz about at the beginning. This applies to all businesses and not simply those businesses that were deemed essential in some of Governor Cooper's early executive orders. So in all likelihood, it absolutely applies to your business, your office, and your office space. Secondly, the immunity is broad in the sense that it covers most conduct. It essentially says that you at your office or at your business are not going to be found liable for a complainant's claim that they contracted COVID at your place of business or office, so long as you are acting reasonably. The only exceptions whereby coverage for immunity would not be extended are in situations where a business or office is operating in a grossly negligent manner, where if they are just blatantly disregarding guidance and directives as to safe practices and best workplace operation during this reopening. And so, in essence, if you are doing your best to follow the guidance and directives, which we know is evolving, and there's a lot of new guidance coming out daily, but so long as you are doing your best to ensure that your business is operating safely as best it can under the current guidance and directives, then in all likelihood, you will have the benefit of this civil immunity statute, such that someone claiming they contracted at your place of business will not be able to recover on a liability basis against you, so long as you're doing your best to follow guidance and directives. One thing that the statute does provide, though, is that businesses that are in operation and open should be providing notice on their premises, both for customers, clients, and employees, as to what steps they are taking to cut down on the transmission of COVID-19 on their premises. Admittedly, while the statute provides that notice should be given, there's little guidance as to what that notice actually should be, how it should look, where it should be. But I think just relying on our own common sense, there's a lot of tips that we can pull together as to what would be a best practice with respect to the notice provision. First, considering where should notice be posted as to the steps you're taking to prevent transmission of COVID. I would suggest that there should be physical copies placed in your physical premises that's visible to employees, customers, clients. So there should be a physical posting of notice somewhere as to the steps you're taking. Additionally, if you have a website or social media page, I would encourage you to provide that notice there as well. The more places it is, I think the better likelihood that you would be seen to be acting reasonably under the circumstances. So that sort of covers where you should consider putting the actual notice. And then second, what should the notice contain? I would suggest that a notice probably should include a description of what the minimum entry requirements are for guests and employees on your premises. That can include things such as wearing a mask, temperature screening, if that's something you're enforcing, or any other requirements that you have in place. I would include in the notice what those entry requirements are for your office and place of business. Additionally, I think it would be wise to include what are the requirements for being on the premises. That might include distancing requirements, other requirements with respect to some of your common spaces that you may put in place. List those out and be clear for people coming on your premises what the expectation is with respect to their conduct when on your premises. In essence, what you really want to do is just make sure that people are informed of what is expected while on the premises. And by providing notice, they have a chance to read it, they have a chance to understand it, and hopefully thereafter to abide by whatever requirements you have put in place to hopefully cut down on transmission. So that's the key takeaways. Just continue to be cognizant of the guidance and directives coming out about workplace safety. Do your best to implement them in your workplace, such that, worst case scenario, if somebody were to contract COVID-19 on your premises, in all likelihood, you would have a reasonable defense to any legal liability that they may seek with respect to your business. And then last, the timing. This legislation applies to claims that someone may bring on or after July 2nd, 2020, and it runs through 180 days after the governor's emergency orders are expired or rescinded at some point. So it even gives coverage post expiration of Governor Cooper's emergency orders, but it is limited in essence to a certain period of time, and this this legislation, unless continue or amended such that it continues further, will have a cutoff 180 days after the emergency orders expire. Seeing no questions on the immunity legislation, I briefly want to wrap up with non-compete. Some of the issues that we have read about and also had clients ask questions about are when we have employees that have non-compete, if they are furloughed and then subsequently terminated possibly, when does the time for the non-compete begin to run? Again, since some of these issues are novel, there's not a whole lot of authoritative guidance on these, but we would suggest that just knowing what we know about non-competes and specifically given the current situation, in all likelihood, the time period for the non-compete is likely going to run from the time that furlough began. So I think employers should just be aware of that, be thinking in that context that in all likelihood, the non-compete time period will run from the time of furlough and not a later time period at the point of termination. So just be aware of that, be thinking about that, that it probably may be an earlier time period than perhaps you originally thought. And then a second question is just how are courts going to handle enforcement of non-competes in this COVID-19 time period? Obviously, a non-compete in essence seeks to prevent an employee from obtaining certain employment for a particular period of time. And so given the larger environment of unemployment that we're facing, it's possible that courts may not have a good appetite to enforce even reasonable and legitimate non-competes in the current environment, just because they may find that enforcement of that non-compete imposes more undue hardship on an employee in this current environment of unemployment than it should, and that the business's legitimate interest in a non-compete is outweighed by that employee's interest in being able to earn a wage. So again, you know, we don't have a lot of guidance on how courts may handle enforcement of non-competes, but certainly something to be aware of, that whereas in normal environments, a court may be more likely to protect the business interest, here they may have more sympathies for the employee and their ability to find subsequent employment if they are terminated. Some additional things to consider, perhaps some of your businesses have restructured their business operations slightly in the COVID environment. And so one thing that you might want to think about is, does the restructuring of your business somehow impact the enforceability of the non-competes you do have? Do the non-competes adequately cover the changed business operation that you have? So even if you're not terminating people and not furloughing people, if you're in a fortunate position not to have to do so, at some point in time, it may be worth revisiting your non-competes if you've undergone any type of restructuring or change in your business model, just to evaluate whether those prior executed non-competes continue to cover the interest, the business interest that you have, and just look at those at a later point in time. And then some additional considerations are, if you do have non-competes with employees and you do want to hopefully try to enforce them, just review them and make sure that in the process, if you're having to furlough or terminate people, that you are not doing anything that might breach that non-compete, such that the employee could argue that it's not enforceable. So again, just go back to your non-competes, review them before taking any action with respect to an employee, just so you're aware of what the requirements of that particular non-compete are. And then the last thing that I'll mention is that if you are unfortunately looking at a situation where you may have to make some layoffs of a number of employees, it could be worthwhile looking at that group of potential employees that you're going to have to furlough or terminate and evaluating which ones have non-competes and which ones you know, may be more important for enforcement purposes, and perhaps that plays into your decisions about who ultimately gets laid off. If there's a way to avoid a situation with an employee that you think is key, and that where enforcement of a non-compete is important, perhaps there's some value in trying to find workarounds to not include that employee in a potential layoff if enforcement could be difficult. So that's sort of just some general thoughts on non-competes looking forward with respect to y'all's businesses. I think we're right at the 9 o'clock hour, so just being mindful of your time this morning. We don't want to run too far over. But again, as Will said and Alan, if there are questions based on anything that we have touched on this morning that you'd like to follow up in more detail on, feel free to reach out to either Will or I or Alan, and we'd be happy to discuss those questions with you.
There is one question that popped up, and I'll just go ahead and answer that very briefly. It probably won't be a complete answer, but if a business is operating reasonably to protect its employees from exposure, but an employee refuses to come to work, can we terminate? They have been working remotely and their position allows it. However, we want their presence in the office. So that boils down essentially to an ADA issue. Coming to work is a legitimate job requirement, and you can, of course, make someone come to work and terminate them if they do not. COVID-19 in and of itself and by itself does not change that. However, the question, there would need to be more facts known about the question. If this employee is saying in some way that he or she is elderly or has diabetes or has some other type of underlying condition, I think the analysis would change greatly, particularly since working remotely seems to work for this employee. That would probably be considered a reasonable accommodation. If none of those circumstances exist and the employee is just more comfortable at home and they like working at home better, but the employer works or would prefer their employees to be in the office, then I think the answer is more likely to be yes, the employer could force them to come back. But again, you would want to look very detailed at the facts and circumstances before making that decision. Okay, Alan, I think that's it for me as far as responding to that question.
All right, well, thank you very much, everybody. Thank you, Will and Jessica, and thank you, everybody, for attending today's webinar. As we've already covered, if you have any questions regarding the information presented or any other questions whatsoever about employment law in these challenging times, please feel free to contact us, and we'll be happy to discuss them with you. And on behalf of the firm, thank you again, and have a great day.